This is Richard Jacobs from My DUI Attorney, and I'm here today to do an interview with Kenneth Wincorn, criminal defense lawyer out of Dallas, Texas. How you doing, Mr. Wincorn?
You're doing very well, thank you.
Yeah, thanks for taking the time. I appreciate it very much. My first question for you is, general one. What motivates you to be a criminal defense attorney, and why in particular do you tend to now work on DWI cases?
Well, Richard, it's a career that's more rewarding than most. How often can you find a job where you can make a living saving families, and
Okay.
reputations, and preserving their freedom?
Yeah.
It's one of the only careers where you deal with constitutional rights on a daily basis. DWIs are the most common offense and are often the result of inaccurate guesses by police,
Hmm.
guessing about the reasons for erratic driving. It's an issue of fairness and really an abuse of the system. And it's an extremely important area that affects a tremendous number of people in this country.
Okay. And so, in the time that you've been handling these cases, how many do you think you've handled, and in how long a period have you been defending these kind of cases?
I've been defending them since 1972, so
Wow.
quite a while. And there's been thousands, a tremendous number of cases, all different types, boating, aircraft,
Hmm.
in addition to the standard automobile cases.
Okay. So, in all that time, is there any typical DUI defendant? Do you get more first timers or more men or women, or is there anything that you've seen where there's a commonality in who you're defending?
Yeah, I think that normally there are people from their early 20s to their mid 30s to 40s, fairly young in most cases. Um, they middle income generally. Some poor people. There tends to be a tendency on the part of the police to arrest more minorities, people that they feel that they don't feel much empathy for.
Okay. All right. Any other commonalities that you see?
Well, I think in particular Hispanics are arrested more than any other group.
Really? Huh.
It's a shame, but it's definitely true. In some cases, it's because of the emphasis right now on immigration and the idea that they may trap someone.
Oh, okay. Okay. So, of the clients that you've represented, how about their blood alcohol levels? Do you tend to get people that are close to the point oh 0.08 limit, or people that are grossly over the limit?
They're usually closer to point oh 0.08.
Okay.
It's unusual to have someone who is grossly over the limit, and if you do, then normally it's not a trial issue, but
Okay.
it's generally on the lower end.
Mhm. And how about DUI from alcohol versus drugs? Are drugs coming up, and is it harder to work with a drug DWI case, or the same as alcohol?
With a combination, it's called the synergistic effect, and yes, it is more difficult because normally there's a presumption that you are not intoxicated if you're below point oh 0.08, and that you are intoxicated if you're over.
Okay.
However, if you have a combination of drugs and alcohol, that doesn't apply. So you could have a very, very low alcohol level, and then the officer is going to take the position that you're impaired no matter what the limit is, if you admit that there are drugs in your system, or if they find drugs in your system.
Hmm. Okay. So, is there anything unique about the DWI laws in the counties you serve, or in Texas itself versus other states?
Well, it depends on which states. There are tremendous differences from state to state. In general, the laws have become more uniform, and as we've had more emphasis from certain public groups, Mothers Against Drunk Driving in particular, all across the nation, we've seen the much more uniform DWI laws.
Hmm.
However, there are tremendous differences from county to county, from rural district to major municipalities. Those that have smaller numbers of people tend to be more strict, and it's more difficult to get a fair trial in some of these smaller towns.
Hmm.
It's hard to compare from state to state. The laws
Okay.
are substantially different.
Well, within all the, I mean, Texas seems to have a lot of small counties all clumped together. Are there any other unique and unusual things that you see besides, rural versus metropolitan counties? Any other differences?
Well, I'm not sure that there are major differences other than those based on demographics. The number of minorities, the attitude toward minorities. Police in some of the counties are somewhat uneducated, becomes less trained. So from one area to another, you do take a different approach toward the DWI, toward defending the client, and it's very important to know the difference from one county to another.
Okay. And you mentioned that a lot of Hispanics tend to get, pulled over and arrested for DWI. How about immigration? What if someone's not a citizen if they're a resident alien or if they have a green card? Can a DWI affect their immigration status? Can they be deported or any of that stuff? Okay, I'm going to repeat the question. Um, so you said a lot of Hispanics get pulled over and arrested for DWI, and I'm sure there's some percentage of them that are resident aliens or have green cards or some stage of immigration. How does it affect them? Do they tend to get deported, or what happens with the immigration side of DWI?
The impact depends upon their legal status. If they are a permanent resident, they will not be deported generally for a first DWI. However, they're going to have a major problem with getting their citizenship within 5 years of getting a DWI because they're considered to be a bad moral character. Moral character becomes a major issue for citizenship. If they have had multiple DWIs, if they've had 3 or more, then there may be a problem depending upon the length of time that they have been sentenced to jail. It's a 5-year. If the total of the sentences, DWIs and others, exceeds 5 years, then they may lose their status as a permanent resident. If they are caught, if it's a DWI with a child in the car, that's considered a particularly serious offense, and that can affect the permanent resident or green card holder. It's
Okay.
also true if there's a death or serious bodily injury, but a standard DWI first will not result in deportation for a permanent resident. If they are in the process of getting residency and there's an issue as to character, as to good moral character, then there will be a major problem. And this has to do with someone who is trying to change their status. In the interview, there may be a problem. If they are not a permanent resident, if they are illegal and they're picked up, they're going to have a bigger problem, possibly a larger bond if they're going to be released at all.
Okay.
If they have if they have been in the country for more than 10 years and they have U.S. citizen or permanent resident spouse or children, parents, then there may be the possibility of their not being able to adjust their status or being found that they are not of good moral character and they may lose a hearing when they're trying to get their status.
Okay.
Very serious problem.
All right.
And actually not just in the country, in other parts of the world too.
All right. So go ahead. What else do you have to add about immigration and DWI?
I wanted to add that when someone's picked up for DWI and they are not a permanent resident and they're not a citizen, they are very likely to be turned over to immigration. That means that once their bond is posted for the DWI, they will then have to deal with immigration hold, and they may not get a bond automatically issued. So it's really important, if possible, before they make the bond in the DWI, if they are not a citizen, contact an attorney and ask what should be done, what they should be prepared for beforehand. And it should be an immigration attorney, one that knows both, hopefully both, criminal and the immigration side.
Okay. Fair enough. And all right. Well, on on a slightly different subject, are there laws in Texas that address drivers that have blood alcohol levels of below zero point zero 0.08? Or, and you mentioned this, drivers that have drug metabolites in their system, but they're not necessarily intoxicated.
Well, DWI in Texas doesn't require that you have to be over zero point zero 0.08. You could be at any level. The question really is, if you're below, there's a presumption that you're not intoxicated. But if it affects you so that you lose the ability to function properly, you lose your mental and physical abilities, and you're not able to maintain, to be able to drive safely, to be able to control the vehicle, then you can still be found to be intoxicated. It's just more difficult, and there is a presumption that can be overcome by action, by what's observed. So that doesn't solve the problem just because it is below zero point zero 0.08. Generally, here they will assume that it's below zero point zero 0.08, that there's something else that's causing you to be intoxicated, and they will still charge you.
Okay. Okay.
It's very low, they may release you, but it's very unusual to see someone released.
Well, yeah, in some states, like in New York, they'll have driving while ability impaired, which will cover below zero point zero 0.08 offenses. And, in some states like Arizona, they have impaired to the slightest
Right.
degree. And that's why I wanted to know about Texas, if they had any
Well,
particular.
we have with public intoxication. We have obstructing a roadway, which is an offense that just a lot of DWIs are reduced to if they can't. If the state has a problem proving their case,
Okay.
but there's still a possibility that they might be able to. So the defense feels it's in the best interest of the client to compromise. So we do have some fallback positions.
Okay. All right. So, if anything, I mean, what's your best tip when someone's just been pulled over and they've been drinking a little bit or a lot? Is there anything they should or shouldn't do that would help or hurt their potential case?
Yes, assuming that they've had anything to drink at all, the first thing that I suggest to everyone is say you would like to speak to your lawyer. You won't be allowed to. However, it's going to put them in a position where you at least invoked your rights. At that
Okay.
point, there is no advantage generally to volunteering anything. Just insist you want to speak to your attorney first. It's a very difficult thing to do because normally you have an authority figure standing in front of you, that police officer, and you don't know what he's going to do. The fact is, he really can't do anything. If he doesn't have any facts, then your case is at least a trial case, and there really is an issue. All of the tests that you're given are really devised so that, in a sense, you're going to have a major problem performing them.
Okay.
Very difficult to perform most of those tests. Most people can't do it. In the middle of the day, having nothing to drink, trying to stand on one foot the way they want you to do it, or going heel to toe, 9 steps, turning around exactly the way you're instructed to, is difficult, if not impossible for most people.
Right.
So at night, when you've been out partying, or just if you've been out with friends or doing nothing, it's going to be much more difficult. So I'm just thinking about other things that they should do.
Yeah. In the vein of not giving the police any extra information, what if they're really pressuring you? They're saying, "Oh, I can tell you've been drinking, and I know this, and I know that, and if you don't tell me some information, that's gonna be a big problem." I mean, if you're really being pressured, like literally, what would you say to the police? What words would you say?
I would say I don't wish to make any statements at this time. I wish to speak to my attorney. I don't wish to say anything. Constitutional right to remain silent, and I think it's important that I talk to my attorney before I say anything. I know it's going to be difficult because the police officer is going to be very unhappy. You've done exactly what he does not want you to do.
Okay.
Because essentially, in cases, you've gutted his case. It really has nothing to go on. The only thing that's going to be a major problem is going to be if you can't stand up. If that's the situation, nothing's going to help. Or if you were driving erratically and speeding, and there were some terrible facts. But in most cases, you're on video. In Texas, almost all the cars, police cars, highway patrol cars, have video equipment,
Okay.
and there's sound and video. So remember, you will be watched. So everything you say and everything you do is It's going to be played back for the district attorney and ultimately, possibly, for a judge or a jury.
Okay. All right. So, when you're defending someone, what kinds of help can you provide? Like, have you been able to, for instance, reduce jail time, or not have them have an ignition interlock, or what kind of benefits do you bring to the table when you represent someone potentially?
All of those things are negotiable. That's assuming if the person is guilty of the offense and all he wants to do is just to negotiate, which certainly does happen. There are instances where people are impaired, they admit it, and the video is not good, and there is no sense in trying it. But then all of the other terms of the probation can be negotiated with the district attorney. And sometimes with the court, because even if you don't like what the district attorney does, there's what is called an open plea, which means that you go to the court, you reject what the state has offered,
Okay.
and the judge has, once you've entered a plea of guilty, has the unbridled right to decide what the terms of probation will be, the length of probation. So we can negotiate. So we have an opportunity to negotiate both with the state and with the judge if we don't have an agreement.
Okay. And I know it's hard to make a blanket statement, but like what level of success have you had in mitigating some or all of the charges and fines and problems that people face when they're accused of DWI?
I almost always have success in negotiating below what's offered initially. Probably the most important thing that an attorney's function is to help to decide whether the case, whether there's a good probability of success in trying the case. There truthfully is not very much disadvantage in trying a case other than expense. If you try a case and you lose it, the penalty is essentially going to be close to the same as if you negotiated it. So for many, many people, if it isn't prohibitively expensive to try the case, it is definitely in your advantage to do it.
So there's no penalty that you see that the judges will get mad that you're clogging up the court system and you're trying your case and punish you more than they would otherwise?
Rarely. There are judges who do, and you have to know your judge before you go to trial before him. When I go to small counties or when I go out of state, I'm always try to go early, meet with the court personnel, meet with the judge, generally the bailiff in the court. He's a tremendous amount of helpful information. The court coordinator, other people that can say this is what this court's like. This is what you can expect.
Okay.
When we're here in the Dallas-Fort Worth, North Texas area, of course, we know, but because we've dealt with all the judges before. But when you get away from this area, from your immediate comfort zone, you tend to try to do all of that, get all that information well before we get to the point of making a decision about how to try the case.